Good morning, welcome back. This is Daybreak and thank you for staying with us. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. The question on the abolition of death penalty in Kenya is what we're discussing along the contents of the two bills presented to Parliament by the consortium. Of course, this emanating from a consortium of organizations that come under the umbrella of the National Council on the Administration of Justice in Kenya, and the two bills, the Criminal Procedure Code Amendment Bill 2023 and the Penal Code Amendment Bill 2023 that seek to reform the country's approach to capital offences and generally the criminal justice system, and the overhauling of the same in doing away with what many have been campaigning for, which is the death penalty. Steve Ogola is with me in the studio, an advocate of the High Court, and also Faith Odhiambo, the Vice President, the Law Society of Kenya. We have just seen of Irungu Horton, who has rushed for another engagement. Thanks, Steve, for staying with us. And on the question of the question on one that I did ask Irungu Horton on and this was in regard to the question on the presidential, or the head of state at any given time, because there's a proposal to get the exact wording here, which is as contained in some sections of the bills that have been presented to the National Assembly, of course, subject to debate and approval by the National Assembly. It removes the presidential pleasure doctrine, which the courts have held is unconstitutional, because largely, was it a case of concentration of power on the presidency and that dispensation, that is the current constitution we have, where we have had other institutions that are also bearers of power? And how significant is this move being taken away from the mercy of the president?
I think that is an important clarification. Previously, Section 162 of the Criminal Procedure Code provided that persons who are unfit to stand trial, or maybe who are unfit at the time of commission of the offense, be held in prison at the pleasure of the president, which means then they would be held indefinitely. Now, this new provision says they would not be held in prison, neither would they be held at the pleasure of the president, but rather they would be removed to the hospital where they'll receive treatment, and there would be someone to provide surety, that while they're receiving treatment, they would not cause more harm. Perhaps after they have recovered, they could be rearrested and retried. That is a major shift, because it's a major shift that is consistent with jurisprudence developed by the High Court. The High Court has been doing an amazing job. I've read decisions by Justice Majanja, Justice Mativo, who have said to remove someone from the justice system and to defer his fate to be determined by the president is unconstitutional, because the president should not and does not have the authority to control the outcome of justice processes. So already courts were battling with that question, and they already declared Section 162 unconstitutional, and therefore the amendment is a welcome relief that now aligns the law to the jurisprudential trend. So in short, where we had so many people who are mentally challenged committing offenses now being removed from our communities and being dumped in prison, now they'll be taken to the hospitals. And also, persons who may have committed an offense while they were mentally fit, but now are produced in court when they are mentally unfit. You see, right now the procedure is persons accused of murder must undergo a mental assessment for fitness to stand trial. But sometimes, even by practice, if you are counsel, or maybe there's reason to believe that the person before court, the accused person, is not mentally fit, the court could direct a mental assessment test. The problem with those mental assessment tests is that if you are found to be unfit to stand trial, then you'll be taken to prison and held there indefinitely. So families have been very anxious, and lawyers have also been very apprehensive that because the justice system takes longer for the wheels to turn, it is safer to just plead not guilty, suppress the fact that you're mentally ill so that the trial can proceed, especially where the lawyer feels that there's no evidence that could lead to a conviction. So people have been making strategic decisions, because if you don't make that strategic decision and you tell, if as litigation counsel, if I signal to the court that my client may not be fit to stand trial, the unintended consequence is then they would be held indefinitely in prison, pending determination of his fate by the president, and therefore lawyers will tend to suppress that. But now with these new changes in jurisprudence and the law, I think the first thing where the case demands, where the particular case facts demand, you would require a mental assessment, and if you're found to be unfit to stand trial at that time, then you'd be taken to the hospital and not remanded in prison. So that's a major shift. Yeah,
and that's until it's established that you can stand trial. And you have mentioned the aspect about assurity.
Yes, so I've just clarified 2 points when it comes to mental fitness. There is mental fitness at the time of commission of the offense, and then there is mental fitness at the time of institution of criminal proceedings against you. Yeah. If you committed the offense when you are mentally unfit, and you've been brought to court when you're still mentally unfit, you'd be taken to the hospital, and that would be the end of the matter until the day you recover. If you recover, the prosecution can then reopen the case. If you are fit at the time of commission of the offense and unfit mentally at the time of being charged, you'd also be taken to the hospital and then they'd be discharged until the prosecution thinks that they need to rearraign you in court. So the anxiety that has been addressed now is that we no longer have to rely on the mercy of the president, who most of the time is not even aware that someone has been taken to prison and is waiting on his goodwill to be released. So the Judiciary has held before that is unconstitutional, and I'm happy to see our laws being aligned to correct that. Okay.
Faith, coming to you, there's clarity about that. And it seems that in every step that is made, that has been made for the past 13 years, it pointed towards the making up of a society and a judicial process that largely serves that society. And of course, I'm locking ourselves from what has been the past dictates as contained in the Penal Code. For example, how key is it now that power will be taken under this proposal from the hands of the president, literally, who will otherwise determine the fate of those who are unfit, and now that dependent on the recovery process for them to stand trial once established that they are fit to stand trial? How key is it, especially from the High Court's perspective on the past judgments that were rendered by judges of the High Court?
Now, any particular crime, the question should be, what is the expectation? And for any offender, there should be a fair, methodological, meaningful recourse to those who have suffered loss. Now, if this person, at the time of commission of the crime, he was not mentally fit, now the question is, are you able to hold him liable or accountable for those crimes? Or two, the second scenario that Steve also alluded to is at the time of taking plea, can we say that he's fit? Now, there's the victims that have suffered loss vis-a-vis, we are looking also at a situation whereby we have to, in the justice system, be able to determine what recourse is fair in that justice system. Now, this is a welcome move because it also brings into the question who is in control of this process. Part of the independence of the judiciary is that they should have control in the criminal justice system. What judges are now trying to tell the parliament or the drafters of the law is that this justice system should be limited to the judiciary. So by taking it and having you taken to the hospital, it gives a fair analysis that the courts will be able to make a clear determination upon your examination. Then the courts will be able to now review post. A doctor gives it the report, and they'll be able to review whether you're able or capable to stand trial. But the important thing is that this whole process, who is in control of that process? It's back to the judiciary. The judiciary should be the one that is in control. And I must say that I think it should go even a bit further. Even the getting amnesty should go into the question of parole. Shouldn't we have more of, in the legal justice system, under NCAJ, be able to control the question of whether someone should apply for, early parole or get amnesty with regards to any criminal offenses? Because as much as you'd want to say we leave it to the president, who should be in control of the justice system? It should be limited to the judiciary. And I think that is what the judges of the High Court are alluding and moving towards, to try and tell the executive these powers should be limited and controlled solely by the judiciary. By this move, bringing it back to the judicial system, because even in other matters, even in between a matter, you see the offender is unwell, the accused person is unwell, the court will have to issue orders. You go for checkup. When you're ready to proceed with the matter, the court issues orders again, and the matter proceeds accordingly. And this is what the High Court is saying, and that's why this is a welcome move. It brings back that question that who should be in control of the entire justice system. And that's why I also say it should move a bit further. Even amnesty, the power of amnesty should be brought back to the judiciary. We should have a committee under the NCAJ that reviews, and at the end of the day, they're the ones who make that recommendation. Even if the makers of the law want to keep it that the president grants that amnesty, but it should be under consideration and recommendations under the NCAJ or entirely under the judiciary.
Okay. Part of the other proposals, Steve, is the termination of cases now contingent upon the permission of the court, or the green lighting that is supposed to be coming from the court. I mean, are we getting the right footing here in the case of now this power being exercised by the right institution as the Constitution dictates?
Well, I think this is, again, one of the innovations we are seeing now, because Section 82 of the Criminal Procedure Code, as it is, gives the power to terminate cases under what we call nolle prosecute to the Director of Public Prosecutions. That is also consistent with these powers under Article 157 of the Constitution. But there have been concerns that the prosecution or the DPP has been terminating cases, sometimes without justifiable reasons, and therefore this amendment seeks to require the permission of the court. In reality, or rather in practice, I have seen courts intervening, and requiring reasons why the cases should be terminated. So it's not automatic, but the courts has been intervening and interfering with the DPP's power to terminate cases without a legislative underpinning. But now Section 82 of the CPC now mandates the court, or the trial court, to require reasons and give permission to the termination, which could raise questions on the level of interference of the court's interference of the DPP's mandate. But I think if the court is of the opinion that the termination of those cases is for collateral reasons, the court could say, no, proceed. And of course, then we would see it like this would implicate corruption-related cases, where sometimes, prosecuting corruption-related cases requires heavy political capital or support. If the administration in power, for instance, is not keen on advancing or deepening its commitment on their own graft, it could demoralize the prosecution, and that can slow down the momentum on prosecution of corruption-related cases. And therefore, you can see a wave of withdrawal of termination of cases, but then the court now is permitted to puncture the process of withdrawal by requiring reasons, and actually now the practice is the prosecution counsel must make a formal application in court for consideration so that the court can give a ruling whether the termination is merited or not merited. So they'll be determined on case-by-case basis. But the upshot of it is the decision to withdraw cases or terminate cases is no longer the exclusive decision of the DPP. That decision is subject to supervision of the court.
Okay, and what happens then in instances where, Steve, for example, as we have seen, and this largely informed the ending of the case, that Rigathi Gachagua had faced as MP, then for Madeira constituency, before becoming the deputy president, wherein the investigating officer who was leading the case, that is Kuria Obadia, said that in an affidavit filed in court, that he was rather pressured to trump up charges against then Madeira MP, that is Rigathi Gachagua. I mean, in such circumstances where officials of at the Directorate of Criminal Investigations, which is a key pillar in the criminal justice system, say that they ought, as required by law, and doing the opposite in trumping up charges, as he had said, and this informing the DPP withdrawing that matter from the court. I mean, tell me about that and how such circumstances are likely to affect the undertakings of business by the criminal justice systems and pillars, for example, like the DCI, which are very key.
I think I'm happy to have read the affidavit in the DP Gachagua's matter. And what is the pressing concern arising from the trial of the DP, of course not to defend him, is that the admission that the DCI were acting at the direction of some political operatives, which means there are some people in this country who do not believe that the justice actors need to act independently, as is anticipated in the Constitution, and that political influence can direct the way investigations go and whether someone is charged or not. And therefore, if a political decision has been made to charge a particular person, then the investigative agencies would pick the cue and hurriedly investigate, and whether they find evidence or not, they would still recommend that he should be charged. And I think during Haji's time, we had a lot of problems within, we witnessed a lot of tiff, let me call it a tiff, between the DCI and the DPP. Because DCI was susceptible to external manipulation from the office of the president, and they made decisions to investigate and to recommend charges without accompanying that decision with the evidence that is necessary to mount a trial. Not evidence that is necessary to secure conviction, just evidence that is necessary to mount a trial, which means DCI is acting in good faith, what we'll call prima facie evidence. And what they did, once they investigated hurriedly, they took the investigation file and the draft charges to court, and then they just shoved it to the prosecution counsel, who had limited or no choice into that, just to prefer the charges. So then you had people being prosecuted without evidence that corresponds to the charges that they were facing. Inevitably, those cases then had to be terminated. I think the challenge I've seen in terms of political manipulation or influence in the criminal justice system is that whereas we've done everything we possibly can in terms of reimagining and reconceptualizing the criminal justice system, including strengthening the institutions that are responsible for investigations and prosecution, and even the trial of these cases, a lot remains to be done, and that a lot that remains to be done cannot be subject of litigation or legislation. In essence, if you have a carefully renovated legal infrastructure where the internal architecture of the law is as solid as it can get, but the people responsible for implementing the law, or the people responsible for providing the right context in which the law can be implemented, are not co-opted in that philosophy of independence, then you'll see people sneaking in through the back door, attempts to influence the outcome of the criminal justice system, which means our laws and institutions are as strong as the environment in which they operate.
Thank you.
So DCI admitted massive interference by political officers, especially the executive, and that interference meant people who ought not to have been charged were effectively charged in court. Now, when you evaluate evidence, you find that there's no evidence to support those charges. I think insofar as termination of charges were concerned, I am 100% in support of the decision to terminate those charges, where instances indicated that evidence support those charges were not there in the first place.
Thank you. Faith, coming to you on this, I'm looking at the proposal, and the legislation seeks to redefine, for example, robbery into categories. First-degree robbery, for example, involving one being armed with a firearm or offensive weapon and wounding or causing violence to another person. And second-degree robbery will now include threats to use actual force against a person or property to obtain or retain stolen property. I mean, of these 2 degrees, does it provide judicial officers with more discretion to determine the severity of punishment between first, for example, degree robbery and second-degree robbery, and how important is this?
Ayub, allow me to first jump into something that Steve was talking about before I answer that question.
Okay.
The question of use of nolle prosequi, I look at it in a different way in terms of the challenge that LSK even lodged against the former DPP was that we questioned on what basis was he acting, because there's the question of independence and also justice must be seen to be done.
Okay.
Because it either means that he had succumbed or bowed to pressure to charge individuals without going through the logical process before you make that decision to charge, or it meant that now that there's a change of regime, he was singing to the tune of the new regime. And that's why we celebrate certain judges, particularly one Professor Justice Sifuna, who is now being seen as the darling of most litigants because he has taken the offense against withdrawal of cases, particularly just corruption cases, without giving formal applications and justifying why you're withdrawing certain cases. And for us, or I would say, as an advocate, we have to have that system that at least there has to be some level of questioning, because we cannot have a system whereby the law is seen that they're special people. There are others that are above the law. And you'd have seen the hue and cry that was there in the members of the public when we see so many cases were being withdrawn to the political class that were aligned to the current government. So it shows either there was no independence in terms of investigation, and it also brings that fear that if I'm not in line with the government, it means that the Director of Public Prosecutions can lodge any accusations against me and take me to frustrate me in court. Or it means that if I'm aligned to the government, then I get protection. So as an independent constitutional office, we have to question what they are doing. And that's why I laud the element of the courts intervening, because we have to have that element of questioning how you're exercising such powers. It's not absolute. And as much as there'll be that push and pull that you're interfering with their powers, you can see even how the society is reacting to the same is that there is support, because we cannot have the Director of Public Prosecution just withdrawing cases without tangible reasons, particularly at the height when the country is questioning so much of the corruption cases. Let me go back to the question that you've raised to me. I agree that it now gives the courts a bit of maneuvering, because the limitation that was there under the current law was that as long as you're found with a weapon, it's robbery with violence. There will be no, and the courts now would be hard-pressed, if you look at some of the decisions of the courts, would be to try and find a way to find you not guilty. That would be the only way, because the law was punitive and prescriptive. You're found with a weapon, that is it. These new amendments, as proposed, give the courts a bit more of discretion to also look at part of sentencing. You look at the age, severity of the crime, are they a first offender, and so many other considerations are done when you're sentencing. So by giving this two-pronged analysis, it allows the courts to exercise more of their discretion in terms of what kind of sentencing that they will met against the offender who found guilty.
You have a rejoinder to that?
No, that's fine.
Yeah, okay. Talking about the phraseology here, and Steve, I come to you on this, and this is the American perspective, that is manslaughter, which is now gone. And here it talks about first-degree murder, including the cause of death of another person by poisoning, poisoning, inflicting grievous bodily harm, or any other type of intentional, deliberate, malicious, and premeditated killing, whereas second-degree murder involves the cause of death of another person through a negligent act or omission in the performance of duty that's not accompanied by an intent to cause death or bodily injury. Talk to me about the twist here in language and the omission of manslaughter.
I think other than the phraseology, manslaughter having the dramatic and unnecessarily dramatic effect, there's really no major shift in that provision of Section 204 of the Penal Code. What we previously called murder, the offense of murder, has now been renamed first-degree murder, and what we previously called manslaughter has now been renamed second-degree murder. The distinction is that first-degree murder, or murder as we knew it before, was that you needed two elements, the intention and the act, the malice aforethought, that when you kill, you must have deliberately planned to kill. You must have acted deliberately. And therefore, those two elements must be established for someone to be found guilty of the offense of murder. The manslaughter, now second-degree murder, is an intentional killing, which then you'd still be liable for a term of life imprisonment. So I guess I don't know the rationale per se for shifting the phraseology, but I think other than just borrowing from Western jurisprudence and language, probably because, you know, when you characterize an offense as manslaughter, it has a more depressing effect than just second-degree murder, which is already consistent with the language used universally. Yeah. Yes.
Faith, I come to you on this because it's a bit interesting because Section 153 and 154 of the Penal Code, under this proposal, decriminalizes prostitution, for example. And this is an interesting subject in the essence that the decriminalization of, alongside that, is petty offense, prostitution, and offenses that punish largely the poverty. How relief is this in light of what the ICJ pointed out as an Amnesty International, other lobby groups, including also some that come under the umbrella of the National Council on the Administration of Justice, of 90% of Kenyans who are languishing in prisons across the country, who, being young and poor, people in remand, in jail, in court. How relief is this for them? And the abuse that often this has attracted from officials in the police service?
Putting the morality question aside, the actual punishment is for living off the proceeds of prostitution. So also there's always been that question of how do you establish someone who is living under the proceeds? And unless it's just the question of poverty, ideally. So I think it brings more of a relief because even in today's society, the level of prostitution, I think it's a bit more sophisticated. So people who are actually doing big business in prostitution are not being captured, but it's only the people who are doing it out of their day-to-day livelihoods. Those who are found openly on the streets are the ones who are arrested. And maybe the question is now maybe to regulate it, because it also brings a greater fear that has been there that internationally is being fought on international human trafficking. So if we open it up without also some level of regulation and protection, what question does it bring to the question of kidnapping and human trafficking? Because most instances, even in child abuse, you'll find, and I'm waiting to see the impact of its decriminalization, if it leads to greater numbers of, you know, human trafficking, particularly on children, on prostitution. That's now the question that we need to look and how to regulate to particularly protect the vulnerable groups and also to ensure that our country does not become a porous area for human trafficking. That would only be my question or fear with that regard.
Steve, does it embody, I mean, talking about the proposal to decriminalize petty offenses, prostitution, and offenses that punish the poverty, does it embody, I mean, the reflection of the Kenyan society, where a large majority of Kenyans cannot access legal aid, for example, have no capacity to do so, rarely are aware about the dictates of the Constitution, and lack representation in a court of law, and this being an area that the officers at the security sector and the police service largely have used flimsy grounds to frustrate many Kenyans. Is this a relief to them, a large percentage of Kenyans who have suffered under the previous contents of the law?
I agree fully. The criminal justice system has been excessively oppressive against the poor. and the rich and the moneyed barely notice that there is a criminal justice system in this country. Because if you look at the majority or the bulk of these criminal offenses, they tend to punish poverty. Offenses relating to idling, you know, which I'm now seeing here being decriminalized, living of prostitution, what I see in section 153 and 154 of the CPC. Really, if you find people standing in Koinange Street, dressed skimpily, then you round them up, you put them in a van and take them, then they charge them with prosecution. That's serious abuse of their rights and discretion, because you're forming an opinion because they are dressed skimpily and they're on Koinange Street, there must be prostitutes. So what has been maintained in the law, running brothels, because then the intention is very clear that this is a place where you come to buy sex, for instance, which then corrupts the morals. But finding someone on the streets, and I think going forward, police officers would not be allowed to round women on the streets and then charge them in prostitution. You know, they would have to do more work to establish that actually living off the process of prostitution. Idling, fouling the air, as we've seen, you know, fouling water. These were petty offenses that had very steep penalties, for instance, because they are allowed for sentences that go up to 3 years. Basically, if you look at what the penal code provided in terms of punishment for petty offenses, rarely would you find the middle and the upper class or the rich and the moneyed getting caught up in those kind of offenses, These offenses were targeted at poor people to try and deny them a legitimate way of earning a living. Because if you're in town, sitting somewhere on a slab, waiting for an interview, because you have no money to go to a restaurant to have coffee, and then you'd be rounded up because you're idling in town. You're idling in town. But I can go to Serena Hotel, sit there, and nobody will come and arrest me for idling. But if I'm in town in a T-shirt, sitting on a flower pot, I'd be arrested for idling. Can you imagine the imbalance, the oppression there? So I think it's a good thing, and I think we need to go beyond the penal laws in the penal code and look at the county laws as well, and do massive reform of those laws to make it easy for Kenyans to go about their businesses without being routinely harassed by city law enforcement agencies. You saw the other day when the Nairobi City County undertook a massive operation, crashing the lives and livelihoods of poor residents who are trying to earn a living by selling their wares where people are. And you can see the manner in which they did it. They didn't care about the value of the property they were selling. Maybe someone has a stock of 10,000. That is all they can raise. You don't want them on the streets, but that's where the people who buy their merchandise are. So instead of providing solutions, you're using the law in an autocratic manner where by a stroke of the pen or by the authority of the law, you then disrupt the lives and livelihoods of the people. You should one day, Ayub, come to court, in the city court. You'd be surprised at the number of people who take plea on petty offenses. I mean, you sit there, you feel like, as a lawyer probably handling another matter, you feel like you just stop your own matters first and deal with these petty offenders who have been arraigned on very flimsy, surely non-serious offenses that surely someone could have just redirected them elsewhere. So I allowed this, the proposed changes to the penal code, where we decriminalize petty offenses because those petty offenses punish poverty more than creating a safe and secure environment. We also plead that we go beyond the offenses on the penal code and look into the county laws and decriminalize most of those offenses so that our people can have a decent shot at improving their lives and livelihood without being harassed unfairly.
Okay. Faith, coming to you, because this largely again affects the operations of the judiciary, and in the financial year 2021-22 and the launch of the annual State of the Judiciary and Administration of Justice report, and there were, numerous and notable achievements done in that financial year. 404,312 cases were filed, of which 257,205 were criminal cases, 147,107 civil cases. The court recorded a case clearance rate of 94%, where 381,317 cases were resolved out of the total 404,312. The paltry remaining 6%, what's the formula and the mechanism with which the judiciary can have a commensurate timeline within which they can dispense off with the matter? Of course, depending on the length and the depth and the threshold of evidence and the nature of the cases. But how can the 6% be achieved? And for Kenyans to access justice, because we have seen many cases that have been in courts for more than 20, 30 years.
I'd say, first of all, our judiciary needs a bit more of staffing. As much as we say we have quite a number of judges and magistrates, I think they're just tip of the iceberg. The kind of cases that are filed on a day-to-day basis, we still need to staff the judiciary more. What I also would like to see from the judiciary is that we have a clear system that will be able to vet how many cases are filed and what is the clearance rate per court or per division. So we'll be able to establish where the challenges and the problems are. I think as a law society, the push and pull that we have continually had with the judicial system with regards to their clearance rates and also with regards to access to justice is you find a lot of times while a court should be sitting, they're either attending meetings, they're attending conferences, they're attending trainings. And so the question is, who takes up that workload for that particular time that there's no access? And also the question of how can we ensure that when you look at, let's say, the Milimani registry, the challenge that has been there recently that even the lawyers were raising was the concern that we couldn't get dates. You have a matter, you have clients who are expecting, their matter to be heard within this given particular period of time. And it took almost a near clamor to a situation where there was a boycott. We wanted to have a strike for the courts now to start making some changes here and there. So when there's no efficiency within the court system, then it brings a question of how can you meet that 6%? And I dare say I think judiciary have rated themselves quite highly. If you look at the number of complaints that we continue to receive with regards to lack of access, numbers that people are not able to access and able to file and get dates for their matters to be heard expeditious. We need, the court has moved into more of using more of technology. So we could be able to track if they are they open more in terms of how many cases have been filed when, and then we'll be able to track where they are stuck and why they are stuck, so that we can also question and see how we can ensure that there's more staffing or support the push. Because that judiciary fund, I think it would really benefit them when they're able to control their resources and their funds to be able to see how best to use their resources, where to hire more, which stations need more staffing, which stations need more assistance, to be able to ensure that justice is served.
Okay. When you talk about staffing, I mean, this comes with the resources and it's the financing of the third arm of the government. And we have seen largely the friction between the executive and the judiciary during the administration of President Uhuru Kenyatta, largely in the aftermath of the nullification of his re-election in 2017, and also what happened with the nullification of the Constitution of Kenya Amendment Bill 2020, that is the Building Bridges Initiative. For President William Ruto's administration, an increment of a paltry some 3 billion Kenya shillings in the current financial year. I mean, this is largely a political process. Then do you foresee a situation where Kenya's political elite or establishment would be happy, for example, in the full actualization and operationalization of the Judiciary Fund, for example, increase their money for more staffing, infrastructure, and also deployment of technology, wherein over the past 13 years, they themselves, members of the political elite, have been so, irritant or irritated with the independence that this constitution has guaranteed institutions of government, and some even calling for its total abolition and suspension?
I'd say the constitution is in the right track as it ought to be. The reality is part and parcel of the head of state's promise was that when he got into office, he would ensure that the judicial fund has been actualized, a question that we are still waiting to see that reality come into play. Because in reality, in any government or any civil government, you'd realize the executive will not always be 100% on the side of the members of the public. And the challenge that we have in this current parliament, we see a parliament that is, the majority of parliament is in line with the executive.
Yeah.
So the question is, the last line of defense for members of the public or recourse remains the judiciary. But if you be able to play a carrot and stick game with the judiciary, that we won't get this if you don't do this. And that's why we saw the challenge that the previous Chief Justice Emeritus Maraga had. He was not able to actually effect a lot of the work that he was supposed to do because of limitation of funding.
Okay.
They were not able to staff. We had the Court of Appeal to date is a huge challenge, even getting your matters heard and determined. Why? Because they were highly understaffed, and now the backlog has been quite a bit to be able to try and move into ensuring that they clear all the cases in time. So we need to have that judiciary fund, and it should be, it's in the Constitution, and we need to see the actualization of those promises that were made come into play, because even the Chief Justice herself reviewed higher the filing fees that that would be implemented for people to file their cases. So that expectation is that when paying more money, then there is expectation of service delivery. Even it's something that the government should also strictly consider, because as World Bank does the index of cost of doing business in Kenya, part and parcel whether investors want to come into the Kenyan system will be how fast you'll be able to actually get justice. As much as I laud the judiciary, particularly for the small claims courts, that has enabled some of the small businesses and SMEs to be able to, you know, file a lot of their cases that have lower value at $1 million and below, you're able to get access to justice in a shorter time. The problem is what happens to the other commercial matters. The Milimani courts is understaffed. They don't have ability to expand, because you're expanding where is the space for expansion? So this judicial fund, it is imperative that they're able to get their fund, they'll be able to plan how the expenditure, that once Parliament approves their budget, they should be allowed to expend accordingly, so that we can hold them accountable. Now that you have access, what are you doing with the money that has been given to you? What is the expectation from the various justice actors? And as a sitting member, the Law Society in the NCAJ, those are part and parcel that we can push. But the reality is that even in the criminal justice system fund, something that we are still fighting for in Parliament is for them to be fully funded, particularly for the pro bono scheme. We have a pro bono scheme that is highly underfunded. So even when you raise the question that we have so many cases that are being filed, the petty offenses, the reason why even you cannot, even for the capital offenses, be able to get adequate number of lawyers to defend them using the pro bono scheme is because it's highly underfunded. And you've seen the CJ came in and also expanded it, including children in conflict of the law. So we need to ensure that that fund is in place and ensure that the judiciary is properly funded.
Steve, the Penal Code still under Section 171 decriminalizes bigamy, and customary and Islamic law, which recognizes polygamy. I mean, nothing much changed here, but probably for context and understanding of this and providing specificity on bigamy. I mean, what does it entail? What is it about?
You know, that is one provision that was out of touch with reality, the Kenyan context, and that provision contradicts other provisions of the law in other statutes, because whereas it's an offense to take more than one wife, the African customary laws permit polygamy. And the law expressly recognizes that you can, under customary law, it's 1 plus n, where n is an infinite number. And I think for our Muslim brothers, it's 1 plus n, where n is 3. So you can have a maximum of 4. So I think that was, I mean, it's just, it has little effect. No one has ever been charged with bigamy in this country, because if, under the Marriage Act, if you take if you're married under a regime of law that does not permit plural marriages, then that would be a ground for divorce, not an offense. You know, married under the civil, you're married under the African Christian marriage, church wedding. That is a monogamous marriage. You have conducted a civil marriage at the Attorney General's. That is the Attorney General's office. That is a monogamous marriage. Hindu marriage, that's a monogamous marriage. So those three doors through which you can approach the altar of marriage do not permit plural marriages. And if you take another wife, then the consequence is not criminal penalty. Yeah. The consequence is divorce proceedings. Customary law, Islamic law, permit multiple wives to the tune of the number maximum of 4. For the Africans, customary law permits infinite number, provided that you can take care of them. So I think that was just one of those colonial relics that have now been removed from our statute books.
Okay, and even as we proceed, and I'll take your last account, so we'll be sampling the feedback here on the broadcast. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir, and that will be shortly coming on your screens here on the broadcast as we discuss this important topic on the contents of the bills presented to the National Assembly by the Chief Justice. And this is from Brian Chemwa. He says, alterations to the penal code can influence societal perceptions of justice and ethics, potentially shaping cultural norms and values that might affect, he says, the definition of crimes, penalties, and legal procedures. Next is from Amnesty Kenya. Kenyans need to support the amendments of these bills, and Parliament needs to pass them to ensure there is a framework of restorative rather than punitive justice, aspects of the penal justice system that need reforms. Babu Michel K says the streamlining of the judicial system and the nature of the cases is long overdue. If you go to industrial area remand now, for example, many are petty offenders and have spent years arguing their cases, which in the end they aren't guilty of. Peter Gesura 89 says, I support the bill seeking to change the death penalty and life imprisonment to 30 years sentence. This will make prisoners to have hope in life as well as get rehabilitated. Engineer Lazaro says bill seeking to exempt petty offenders from prison sentences could plunge the nation into lawlessness if not properly handled. He says petty offenders should be rehabilitated, according to Engineer Lazaro, in chief camps by subjecting them to community service. Steve, one of also standing out cases here is the Criminal Procedure Code, the provision of procedure of protection of intersex persons. And this has been a debate which largely has been of recent, and we have seen the opposition towards the LGBTQ community in Kenya. And this largely has been around the mounting of opposition from groups such as the churches and the mosques and members of the public. How key is it, and this in a dispensation that establishes a secular state and a constitutional democracy where raft of freedoms come with that, and also the right of association given to the LGBTQ following one of the landmark court decisions made this year, early 2023. I mean, how key is it?
I think the formal recognition of the presence of intersex persons in the criminal justice system only signals the kind of reforms that we can anticipate in the future. Because previously, we have dealt with intersex persons as if they do not exist, and yet they exist. So I've seen this proposed legislative reform saying that if they have been arrested, they need to be frisked by a person of a gender that they can identify with or they can choose, which means, although it's not in this provision, which means in terms of the places of detention, you know, we have, for instance, the industrial area remand prison for male offenders. And we have Nairobi West remand prison also, I think, for male and female offenders. We've been maintaining separate facilities for male and female offenders. Where we are going, we will begin to agonize how we can organize and create spaces, places for detention for intersex persons, because they're susceptible to harassment and to humiliation. And I'm glad that the criminal justice sector or system is beginning to recognize their existence and beginning to agonize how to address the issues that concern them insofar as they relate to the criminal justice system.
Faith, is that also one of, I mean, the limit with which this will stretch the imagination of the Kenyan public because of how these freedoms that envisioned in the Constitution that are likely going to, in one way or the other, determine the society's outlook and its prosperity, giving ourselves a so elaborative and expressive Constitution that guarantees everyone the right to exist?
I would say that for intersex persons, even when we start from the Constitution, there's been that clamor for their recognition and non-discrimination, and also the clamor for their recognition at the point of birth. The challenge that we have primarily had is that what would happen is that they are placed in either gender, either male or female. But at the end of the day, you don't know which gender is going to come out more dominant than the other. Or whether, you know, at the end of the day, will there be any physical changes that can be done thereafter? And in light of the same, I find that intersex is a bit different. I would even argue from the LGBTQ. Why is that is not a question of choice or inclination. It's how you're born, bearing both genders. And I agree is our criminal justice system is moving towards that recognition that we have to see how they're treated, because either they have to be able to identify to one particular gender, then they're either frisked based on that, and two, how do we take care of them? How are they detained? Because if you place them with one particular gender, it could lead to their abuse in certain detention areas, rape, and whatever the case may be. So there also has to be that recognition, even the kind of detention centers that are placed for intersex persons. Because it's the reality, it's how they are born. It's nothing that they can do to change that reality. And so our criminal justice system must also embrace and not discriminate against equal members of the society. And I support and I laud the NCG for those amendments.
Also, the Criminal Procedure Code, Steve, gives now, according to the proposal, extends all suspects. I mean, this is right to bail for including those accused of murder, robbery with violence, etc. Is it a creation of fairness during the standing of the trial of suspects under this category?
Yeah, I think what that provision, the proposed amendment does is to realign the Criminal Procedure Code with provisions of Article 49, Sub-Article 1, Paragraph H of the Constitution, which provides that the right to bail applies to all offenders. The CPC previously limited the right to bail, especially at police stations. If you are suspected of to have committed a serious offense, then at the police station you could not be bailed. If that offense was, let's say, related to murder or robbery with violence. Right now, under Article 49, Sub-Article 1, everyone has access to bail. So I think aligning that provision makes a practical sense issue. I think just one comment that could benefit the viewers, in terms of giving an overview of the layout of the criminal justice system, so that they can see the kind of transformation that we've seen, or how we have transitioned. In this country, from the age of 0 to 8, children in conflict of the law, within that age bracket, they cannot be admitted in the criminal justice system. And between the age of 8 to 12, if a child is in conflict with the law, because for children, don't say that they have committed offenses, if they are in conflict with the law, they would be committed to a caretaker or a guardian. And if they are between the age of 12 and 15, they may be taken to a remand home for rehabilitation and assistance, or maybe an approved school. Between the age of 15 and 18, we have a special institution known as the Boston Institution, which provides for holding of up to 3 years, and then they receive correctional training. Between the age of 18 and 21, and many people don't know this, we have, in the Prisons Act, we have a facility known as the Youth Correctional and Training Center, the YCTC. If you fall within that age bracket, between 18 to 21, you could benefit from the YCTC, where you get what they're calling sharp, shocking, and short and shocking treatment, where you're being brought back to reality as a young adult, but gives you a chance at rehabilitation. Then we have the Community Service Orders Act for misdemeanors, minor offenses, any offense that attracts a sentence of less than 3 years. Most of them should be committed to non-custodial sentences, and Faith talked about decongesting prisons. Those are some of the innovations that we have realized, and people who are facing offenses sentences between 4 to 7 years still can be admitted in a parole system. It does actually exist. The Prison Board of Review permits the Commissioner General of Prisons to remit a third of your sentence, which means if you are serving up to 7 years imprisonment, and you've already served 4 years, you could spend the last 3 years outside prison. And long-term sentences like serious felonies or serious offenses that attract more than 7 years, once you've served more than 7 years imprisonment, then you could benefit from what Article 133 of the Constitution characterizes as the power of mercy, which means there are opportunities every step of the way to get people out of the justice system through diversion, through parole, through remission. And all these systems are supposed to make sure that those who remain in our prison facilities are rehabilitated and not necessarily punished.
Thank you. Steve Agola, advocate of the High Court. Your time is all appreciated. And also Faith Odhiambo, the Vice President of the Law Society of Kenya. Thank you, lady and gentlemen. And also earlier we had Amnesty International Kenya Executive Director, Irungo Houghton. We are keeping our eyes on the visit by King Charles III and the Queen, who yesterday were received at State House in Nairobi by the President before proceeding to Uhuru Gardens for the laying of the wreath on the tomb of the unknown warriors. And the afternoon assignment saw the King visiting an organic farm at Mama Lucy Hospital along Kangunda Road here in Nairobi County, and also where another action was happening at the same time simultaneously between officials of the United Kingdom government and the Kenyan government, where the Foreign Secretary of the UK, James Cleverly, and the Education CS, Ezekiel Machogu, put pen to paper with education agreements regarding the support the UK has rolled out for Kenya. Today, the King will also have another busy schedule, and our teams will be keeping track of his entourage. Chemutai Goin, Seth Olale, Ben Kirui, Brenda Wanga, and Mary Mwoki will be updating on the same as his visit enters day 2 here in Kenya. Thanks for watching, and good morning.